Welcome to our today's legal podcast. Today I have with me Mr. Awais Javed.
Thank you very much for inviting me.
And we have today some common questions and really important ones relating to children, because we have seen a lot of families, they struggle with their status of their children. Even if they have sorted their own immigration status, they find it sometimes difficult how to make applications for their children's nationality, or either through registration or through descent, or otherwise than by descent. So there are quite a few options which we will explore today, and Awais has a lot of expertise on this topic. So I'm going to ask him questions, and I hope I will cover all the most important ones and frequently asked ones. So thank you, Awais, once again. So first of all, we will talk about the children who are born outside of the UK, and parents if they have obtained their citizenship by descent. So what are their legal options if they want to register or they want to bring their children to the UK?
Right. So if any of the if child is born outside the UK and parents have obtained their citizenship by descent, which basically means the parents were also born outside the UK and this is how they obtained their citizenship. In that case, unfortunately, they can't pass citizenship directly to their children, but there are two options. So first option is under section 3 subsection 5. In that case, this option is for those children who are already in the UK with their parents, at least one of them is a citizen. In that case, as long as they have lived in a family unit, so parents and children or that child lived in a family unit for 3 years, and none of them have stayed outside the UK for more than 270 days, that is preceding application. So 3 years preceding the application date.
So you mean that before the birth of the child, if they have lived for 3 years at any point?
No, that is a separate category. In this category, if child is already in the UK, so child is born outside the UK and child has now traveled to the UK, and they are living as a family unit in the UK for 3 years. One of the parent is a British citizen or a settled person. In that case, they can apply for citizenship as long as the number of absences are less than are maximum 270 days. In that case, they can apply for citizenship directly for children under section 3.5. They do not have to go through the indefinite leave route where they have to pay a lot of fee, and they can save all that. The other option is under section 3 subsection 2. In that case, this is the option where child is outside the UK, hasn't traveled to the UK, can't travel to the UK. In that case, if any of the parent is a citizen by descent, but grandfather or grandmother of the child in question, in other words, parents of the child, they are citizens otherwise other than by descent. In that case, as long as parents of the child making an application for citizenship have lived in the UK for at least 3 years, and these 3 consecutive years could be any consecutive period in the UK before the birth of the child. So let me repeat that. So if parents have lived in the UK for 3 years consecutive, any consecutive period they can take before the birth of the child, and they have not lived outside the UK during those 3 years they choose for more than 270 days, in that case child can apply for citizenship without applying for any entry clearance visa. So these are the 2 very good options for those children who are born outside the UK to British parents who obtain their citizenship by descent. I hope that answers your question.
Yeah. When you say grandparents for section 2, section 3 subsection 2, so grandparents, are you referring to the paternal side of the grandparents or the maternal side of the grandparents? Or
it could be either of them, so it doesn't matter. So as long as one of the parents of the child, so one of the grandparents of the child, whether it's from mother's side or father's side, they have obtained their citizenship other than by descent, means they naturalized, so they made an application for naturalization in the UK. In that case, as I mentioned, those children can apply for citizenship as long as other requirements are completed.
So, can you highlight what is by descent or otherwise than by descent? Because sometimes people struggle to identify whether they have the citizenship through descent or they have obtained it by other means. So, can you highlight a bit more about
Well,
this?
if I want to make it very simple for our audience, by descent means you are born outside the UK. So if you're born outside the UK and then you become British citizen by virtue of any of your parents who are a British citizen and they pass their citizenship to you, then you are a British citizen by descent. If you are born in the UK, then you are not a British citizen by descent. You are either, if you make an application for naturalization, then you are a British citizen other than by descent, or if you are born in the UK and by virtue of your birth you become a British citizen, then you are a British citizen by birth. So in that case you are not a British citizen by descent. So that's the most simplest form I can explain. Let's put it this way.
Yeah, understood. So, now when it comes to children who have obtained their indefinite leave to remain, let's say after 7 years residency, which is quite common for many applicants, when can their children apply for their citizenship?
Children who have obtained their indefinite leave to remain based on 7 years policy.
7 years policy.
It depends. So if any of these children they are born in the UK, then they have two options. So common misconception is once you obtain your indefinite leave to remain after 7 years, you're born in the UK, you stay there for 7 years, then you've got your indefinite leave to remain. Now you only have to wait 12 months and you can apply for your citizenship. That only applies to adults. It does not apply to children. Children can apply, but they will have to ask for general discretion to obtain citizenship. Now we have had cases where that discretion was exercised in our client's favor, but again it's discretion is discretion. They can, depending on the circumstances, if any other siblings they are British citizens, then you have a better chance. If not, then maybe a less chance, but it is discretion. The other option is that they wait 10 years. So if a child is born in the UK and child has lived in the UK for 10 years, that child can apply for citizenship based on their residence in the UK. Now important thing is if child does not apply, let's say there are countries who do not accept dual nationality, and let's say child has turned 10 years and child still doesn't apply for citizenship and continues, child is 15, 16, maybe 18 years old or older. Even at that time, if child decides that child wants to obtain citizenship based on birth and initial 10 years in the UK, most important part is that you must have been born in the UK and lived continuously for 10 years from birth. If that is the case, child who is not a child anymore, over 18 for example, can go back and apply for citizenship on those basis any time in their life. There is no restriction on the child.
But when they turn over 18, do they have to follow the naturalization process?
Well, they have to follow naturalization process anyway. They will have to make an application. It is a citizenship other than by descent. So they will have to naturalize for this type of citizenship. It's not by birth. So if they are over 18, of course, then that means they have to go through life in the UK. If they don't have a degree in the UK or GCSEs or A levels, they have to meet the English language requirement as well. Those requirements needs to be met based on their age, but they can still apply for citizenship if later on they decide that they want to obtain British citizenship.
Okay. You highlighted that there is a cooling off period of 12 months, which generally applies on adults. So if we are talking about children where this does not apply, do you think the parents should try to make a discretionary application following the successful application of ILR, or they have to wait 12 months before they can request a discretion?
Well, there is no 12 months period for children. So it does not matter whether you apply straight away after indefinite leave to remain, or you 12 months or 13 months or 15 or 2 years for example. After 10 years, if child is born in the UK, child will qualify for citizenship on the basis of 10 years residence, as long as the residence requirement is met. So they have to make sure that they haven't stayed outside for certain number of days. It's 900 generally, but Home Office can use discretion and can go up to 990 days for example, as long as one absence is not more than 180 days. And if it is, then the situation was not in the control of that applicant. So there is no restriction that you have to wait for 12 months. on indefinite leave to remain before you can apply for citizenship. You're asking for discretion, which by well, the clue is in the word. You can apply anytime as long as you have indefinite leave to remain.
We commonly get asked this question: do you guarantee any success in the application? So, because you've been using the word discretion quite a lot, but we get questions from clients that can you guarantee that the child would get, and only in that case I will instruct
Well, the
you.
only help in this case I can provide is give them the email address of Shabana Mahmood, the Secretary of State, and they can ask her. She's the only one probably you can provide guarantee. I can't, as a practitioner, I can't use that word. Well, we can give them the probability. Obviously, as practitioners, we would know if the case has strength or not, and we can tell them, okay, this is a weak case, this is a good case, this is an excellent case, but this is where our powers finish.
Exactly.
You know.
Exactly. As a legal practitioner, you can only tell the applicant about the merits of the application.
Right.
Exactly.
And the strength of the application. But having said that, Home Office, they sometimes you think it's an excellent application, and when the result comes in, you see it's a refusal, and client comes back to you and says, well, the only thing I can say is, Home Office needs to up their standards when it comes to their understanding of the law.
Does circumstances in nationality applications matter? Like if someone has some compelling factors or compassionate grounds for making the children's nationality application, does Home Office consider anything in the nationality application like they do in immigration application?
Yes, you can apply asking them for discretion, but most of the times they have in most of the circumstances, should I say, they have defined under which circumstances they will use their discretion. So even though it is discretion, so which means that it's literally up to them whether they grant citizenship or not, but they have defined, okay, if we are using our discretion and you do not qualify under the Nationality Act directly, then these are the circumstances where we will use our discretion, and they have defined it. This is not to say that it should, having said that, it should not stop you from asking for discretion where you think that there are compelling circumstances. So for example, if as I said, case scenario we have discussed is if child already has indefinite leave to remain, and child wants to apply for citizenship. A child is born in the UK, got the indefinite leave to remain, but does not qualify for citizenship. In that case, I would encourage that you go to the Home Office and explain why it is important that child gets citizenship, if especially in scenarios where child will eventually obtain citizenship anyway in a year or two. There is no point depriving child from of that privilege in advance, when eventually you would know that child will obtain that citizenship. And if child is under 10, good character requirements don't apply, so you can't say that it may be that good character requirements will have a play in the next application in 2 years time, because it does not apply to any children who are under the age of 10.
Yeah, I have a follow-up question about this. So what if there is a single parent, they brought their child into the UK, they got separated, let's say, and they now have a child living with a parent who is a British citizen. The child has lived here for more than 3 years. Do you think it is worth making their indefinite leave to remain application, or shall the parent apply for the discretionary nationality application?
100%. Well, I said 100%, 999%. Well, of course, you can. I know which case you are referring to. It's a case we have recently done together, and we had a success in this case. Again, as I mentioned, discretion is discretion. So if child is in the UK, child has indefinite leave to remain, but both parents do not have indefinite leave to remain, and then we have the recent case of Cohn versus Secretary of State. Yes. So it tells us that this requirement basically is in breach of child's human rights. So if one of the parent is settled, then child should be getting settlement, and once child already has settlement, then child should be asking for citizenship, rather than making child wait another few years before child can obtain citizenship. So yes, I would say go for it. Just make sure that you get legal help properly, so application is made considering all the circumstances which are relevant to this case.
Okay. We've also seen quite a few examples where people have come on a work visa or on a visa which leads to settlement eventually, and now they have a child who is born before their citizenship. Either of the parents who've got citizenship or they've got settlement. Do you think they shall apply for the indefinite leave first and then they go for the nationality registration, or they can simply make a nationality application in a case where the child is born before
parents obtaining
parents obtaining their settled status or their indefinite leave or their nationality?
If child already has leave to remain in the UK, and for example, child as a dependent still has leave for another few months, parents can apply for indefinite leave to remain, because as soon as parents obtain indefinite leave to remain, child who is born in the UK will qualify for citizenship. So child does not have to go for indefinite leave to remain, and it is quite expensive. It's a very expensive application if you make an application for indefinite leave to remain. If you want to be absolutely sure, don't want to take any risks, I don't think there is a risk in it, but in any case, if you say no, I want to obtain indefinite leave to remain for the child as well, then go for it. It's more like a financial question than a legal one. If you ask my opinion, I think it's unnecessary to spend that much money on indefinite leave to remain application, when as soon as parents would qualify for indefinite leave to remain, child can straight away go ahead for citizenship. I would rather spend that money to go for priority service for parents than to spend that money for child's indefinite leave to remain.
For the child's indefinite leave to remain application, that is very clear. Now, a child who was born in the UK, they have lived here for 10 years. So, are there any specific requirements for the children to apply for nationality after they've lived here for 10 years?
Yes, as I mentioned, the only specific good character requirement does not apply to them, but it actually technically does, because when child makes an application, child will be over 10, so it's 10 years and 1 day, so anytime after 10 years, so good character requirement will actually apply. But because child is very young, they can't hold child accountable for anything that went wrong in terms of immigration history. If child has overstayed previously or entered illegally, for example, and because of the parents, they cannot hold that child accountable. The other most important part is their absences. So the maximum number of absences allowed are 90 days per year, per calendar year, during those 10 years. If so, that you can calculate it to around 900 absences
It is quite generous, I would say.
over 10 years. More generous is, even if you exceed those absences, as long as you don't have one absence of more than 180 days, approximately 6 months in one go, then its caseworker has a discretion, as long as your maximum absences are not more than 990. Even if you have absences more than 990, as long as you can show that it was not under your control to get back to the UK. So for example, you had COVID pandemic, for example, or someone, for example, suffered an accident and had to go through some medical procedure, could not travel, for example. In those cases where circumstances were not under their control, still caseworker can use discretion. So it's very, very generous in that sense.
So when you said a good character requirement, does it apply on children also?
Not upon children who are under the age of 10, no. But anyone who is above the age of 10, it does, yes.
Okay, so any immigration related, obviously they were not in the control of the children when their parents brought them into the country. But what other requirements of a good character applies on them? Like, are you referring to any criminal?
Every other good character requirement will be applicable to the children. The only, as long as child is under the age of 18, any offense they have committed, immigration related, mainly, uh, they have an excuse. So what they can ask when they make an application, they can exercise that excuse in front of the Home Office and say that it was not something that was under their control. So for example, they were brought into the UK illegally, for example. In that case, they won't be held accountable. But in terms of criminal convictions, even before the age of 18, this is something Home Office does take into account. but of course you can provide mitigating circumstances for that as well. Anything from the age of 18 above, it's exactly the same for any other adult. So under the age of 18 they can provide mitigation, and it will be considered 18 plus. Again, you can provide mitigation, but obviously they will be held accountable for their actions.
Thank you very much, Avais. You have shed a lot of light on the gray areas where people have struggled for their children's nationality application. I hope this episode will cover most of your questions related to your needs of making application. But again, if you have any questions, especially relating to nationality applications, I highly recommend contacting Avais for your application, and seek at least advice before making such application, because you may end up losing a lot of money because nationality applications are quite expensive. So you can reach out to Avais on his social media channels, on his email. So he has profiles everywhere, so you can easily find him. So stay tuned, and we'll come back with further updates very soon. Thank you.